Hey guys, happy Friday. It's first Friday of family law here at Matheson & Associates. I'm Jammie. I'm the family law attorney that handles those matters as they come through our office. We were going to do a continuation of our last video. However, we have gotten a lot of questions or a lot of requests to get divorced because you guys have been separated for a year, and that's either sometimes referred to as an absolute divorce or a simple divorce or both a simple absolute divorce. But the problem is I think a lot of people don't quite understand what would make a divorce go from simple to complex or somewhat complex depending on your situation. First, typically people call after they've been separated for the requisite time frame, which is 366 days, which is a year and a day, that you've been in the state for a period of 6 months, that you guys haven't really been married for very long, so maybe you haven't really acquired any assets that need to be separated. Like, I don't know, maybe you've only been married for a year or two and you just never bought anything or invested or anything like that. So I think that, there are situations where that occurs. And also you might be one of the very few cases that happens, or people draft their own separation agreement, which is not recommended, but without review from an attorney, and have essentially separated whatever they need to in a notarized writing, and they're just ready to move on because there's nothing left to argue about. We can talk about what happens when you draft your own separation agreement in a later video, but we're talking right now about simple divorces and kind of what you're looking for in order to qualify for that. Typically when people call, I've got a simple absolute divorce and I would like for us to file that and get it done. How quickly can it get done? Our next question is, well, do you have any kids, or do you have any property, or do you need alimony? And when all those questions are yes, it makes that divorce conversation not so simple. So we call that, a complex divorce, and it's a varying degree of complexity because some people may not have kids. Some people just, may make about the same amount or are both financially stable and don't need alimony in any capacity. Or you guys have, don't agree on a custody schedule, and usually we want to try to file all the claims in one so you're not paying a whole bunch of court filing fees. So depending on your situation, depending how things are with your former spouse, then you may qualify, unfortunately, for it to be more of a complex divorce unless we can reach a resolution through a separation agreement or through collaborative family law. So like I said, there's a difference between the simple and the complex. So when you're calling around or when you're calling our office, if you can safely say that you guys have property that's disputed, if you've got children and you don't agree on the schedules, or you need support in any capacity, whether it's post-separation support, alimony, or child support, you definitely need to start considering a separation agreement. This way we can make your divorce final so you don't lose your important rights of equitable distribution, post-separation support, and alimony. Because if we do file for that divorce and that divorce is granted, then that would effectively waive your right to those 3 claims. So you really want to make sure you consult with an attorney before you do that. And again, we are happy to do free consultations with regards to simple divorces and not so simple divorces. And like I said, I defined not so simple earlier. The code to call in with is NSS 25, not so simple 25. And we will be happy to set up a free consultation with you. Thank you.